So we're going to talk about what they owe you for violating you. If you were denied housing due to a background check, that is a violation of your rights. If you were denied credit due to a bankruptcy being on your consumer report, that is a violation of your rights. Even if you were denied a driving job due to a background check, that is a violation of your rights. These are all third-party companies that they are obtaining this information from, and they are housing information without your consent. Under false pretenses, they obtain your non-public personal information, and that is a violation of your rights, and you can sue these companies for violating you. You are not in relationship with these companies. You have no agreement, so that is a clear violation of the law. Federal law. Go to 15 USC 1681N, civil liability for willful noncompliance. It says willful. What does willful mean? Willful refers to acts when you are intentional, conscious, voluntary, and designed to achieve a particular result. So they are intentional about what they're doing, y'all. The law says willful noncompliance. They know what they're doing. Okay, so we're going to read. It says, in general, any person who willfully fails to comply with any requirements imposed under this subchapter with respect to any consumer is liable to that consumer in an amount equal to the sum of A, any actual damages sustained by the consumer as a result of the failure, or damages of not less than $100 and not more than $1,000. It says B, in the case of liability of a natural person for obtaining a consumer report under false pretenses, or knowingly without permissible purpose. Knowingly without permissible purpose. Actual damages sustained by the consumer as a result of the failure, or $1,000, whichever is greater. That was a mouthful, y'all. So you have consumer reporting agencies who knowingly reported information to your consumer report without your consent. You have consumer reporting agencies who knowingly obtain your non-public personal information under false pretenses without an order or subpoena from federal grand jury. And I'm going to show you. They have to have a subpoena. There has to be some type of order. And they have to have permissible purpose from the consumer. So 15 USC 1681B, permissible purpose of consumer reports. It says any consumer reporting agency may furnish a consumer report under the following circumstances and no other. 1, in response to the order of a court having jurisdiction to issue such an order, a subpoena issued in connection with proceedings before a federal grand jury. Oh, wow. Then 2, it says in accordance with the written instructions of a consumer to whom it relates. So you have to have written instructions in order to house information on you. There have to be a court order in order to have information reported on you. There has to be some sort of subpoena. This is what the law is telling you. Permissible purposes of consumer report. So if you were denied housing due to a background check, that is a violation of your rights. If you were denied credit because of a bankruptcy on your consumer report, that is a violation of your rights. Civil liability for willful noncompliance. These people are violating you. Even if you were denied a driving job, that is a violation of your rights. Why? Because they are obtaining your information from third-party companies that are not in relationship with you. You have no agreement signed with these companies. You have no agreement signed with RentGrow. You have no agreement signed with Checkers. They keep record of your driving history. You have no agreement with LexisNexis, who has a bankruptcy reporting in their file on you. That is willful. They obtain your information under false pretenses. So the question is, how do you get paid? How do we get paid? Because they're clearly violating us. If you were denied credit, by law, they must provide you a denial letter, an adverse action letter. So the adverse action letter is your proof. Okay? It's your proof. Everything is about what you can prove. It's not what you know. It's about what you can prove. They failed to comply with the law. They are liable for obtaining your consumer report under false pretenses. So your denial letter is going to explain what led to you being denied for credit. You also want to have a copy of your consumer report. So we're talking about how we're going to hold these people accountable. You want to have that denial letter. You want to have a copy of your consumer report. So if you were denied October 5th, 2024, you also want to obtain a copy of your consumer report reflecting the information within the same time frame that you were denied. This is your proof, the denial letter, okay? And the copy of the consumer report. You want to keep this for your record. If you have not given them written instructions, if there is no order from the court, there's no subpoena, okay? These companies are using background check reports as part of their business operation, and they are violating you. This is a form of identity theft, okay? You did not give them any of your information. Civil liability, willful noncompliance. You always want to keep records of everything. So in court, to prove damages, your denial letter is going to be your exhibit in court. That's going to be the proof. Your denial letter. The copy of your consumer report reflecting the information that got you denied. That's going to be your proof in court. So don't wait to be great.